Let's face it, the words lawsuit or legal action can send shivers down any business owner's spine. Not only can litigation be financially devastating, but it can also drain your time, energy, and reputation, your and resources. And that is why it is so crucial to make sure that you are on the up and up when it all comes to legalities. But here's the good news. Many legal pitfalls can be avoided with the right knowledge and proactive measures. In today's episode, we're going to explore practical steps that every business owner can take to shield their business from potential lawsuits. From proper contract management to compliance with regulations, from employee relations to customer interactions, we'll cover the essential areas where a little foresight can save you from a major headache down the road. Whether you're a startup founder or an established entrepreneur, this episode will equip you with valuable strategies to protect your business and give you peace of mind. Today, we welcome into the studio Chris Roberts. He's a dedicated and skilled litigator whose primary focus is on representing consumers in class action litigation and individual consumer-related claims. His practice has resulted in millions of dollars being paid to consumers and millions of debt elimination. Beyond his legal work, Mr. Roberts is a nationally published author and recognized lecturer on class action issues. Welcome, Chris.
Thank you. I appreciate the opportunity to be here.
I am so excited to dig in because this is an area that I know a lot of entrepreneurs lose sleep over at night. 100%. I know, I've been in their shoes.
And I want to applaud you first and foremost for thinking outside of the box a little bit and having me on this podcast, because typically when you see a lawyer appear on a podcast and kind of give tips or things to look at in terms of avoiding litigation, there's nothing wrong with it, but it's typically a defense lawyer, somebody that represents businesses. And I've always thought it would be really helpful for an entrepreneur or a new entrepreneur, someone established, to actually talk to somebody like me, because you want to avoid somebody like me who files these lawsuits. I feel like that it's very proactive. I've always been wondering why people never do that. So I'm very happy to be here today with you and kind of share some of my insights on these issues with you.
Absolutely. I think it's the perfect person to talk to because you know what it's like on the other side.
Correct.
So let's dive in. So my first question is, because you've seen this, what are some common pitfalls that business owners face? Or what are common legal issues that you see that small business owners face?
So I'm going to talk about a little bit what we do as class action lawyers, and that'll give you a context of the things that I see. It's not all inclusive, but it'll give you some ideas of things that can apply to almost any type of entrepreneurs or as a well-established business.
Okay.
And so one of the things that we do is we do a lot of consumer class action work. And so the areas that we focus on deal primarily with advertising.
Okay.
And so, for example, the big area that we're dealing with right now is telemarketing. That means phone calls, text messages, things of that nature. What we have pre-recorded voice calls. And so what I'm going to say here applies to every business, regardless if you want to do those types of marketing or not. And the biggest thing I would tell you is that on all the things that I'm going to talk about today, it goes back to the old saying that an ounce of prevention really is worth a pound of cure. It's really helpful to have a lawyer talk about these issues and vet these issues with you on the front end. There may be some expense to it, but there can be a much greater expense if you don't do it down the road. And so what I see a lot of are businesses not telemarketing the right way. They think text messages, phone calls, they're cheap. They're easy. We can just dial these lists. And so it's an easy way for us to market. What they don't realize is that there's a federal law, for example, that if you call somebody without the appropriate permissions or they're on the national do not call list, that can be $500 and potentially up to $1,500 for every single call or text. So if you're talking about somebody that's even sending out a small number of calls or texts, like 1,000, that can be ruinous for a small business. So it's really important before you market or you do anything with your business, you have an idea, to make sure that that idea goes through a lawyer to make sure there's not going to be litigation down the road.
Right. And I find it interesting because really this year and maybe towards the end of last year is when I started hearing about the text messaging lawsuits starting to crop up. If you send someone a text and they opted out or whatever, and you keep doing it, it's kind of new landscape, if you will, for a lot of businesses because they don't understand how this works.
Well, it's interesting you say that. And for a lot of people, it's new landscape. But the thing that we do is we use little known laws to help consumers fight back. And this law, the Telephone Consumer Protection Act, has actually been on the books since 1991.
Oh.
But because the text messages are becoming so much more prolific now, and because because technology's evolved, they're becoming cheaper and more efficient to send out. That's why you're hearing more about it now. The other thing too, and I'm not trying to scare your viewers, but you've got to be cognizant of this, is sometimes there's also state laws because people are fed up with getting these types of marketing text messages or calls. Now there are states that have adopted laws on top of the federal law. In some of those states, the penalty can be $5,000 a text message. Or a phone call. So you've got to be very careful about this. And again, it goes back to making sure you have a lawyer kind of understand what your business is, what you're looking to do.
I think your audio cut out.
Oh, so it goes back to...
One sec. I think your audio cut out.
Is it good? Can you hear me now?
Audio.
You can't hear me?
Do you think he can hear me? Can you hear me?
I can hear you. You can't hear me? You guys can't hear me?
There you are.
You can't. Can you hear me now?
Now I can hear you. You cut out. Can you put a marker so that we know that she has to cut that there? Normally I never cut podcasts. We just do them all the way through.
And I can hear you perfectly fine too.
Yeah, you started saying something. We were talking about state law and you went away.
Okay, do you want me to repeat that?
I think so. Do you want us to go now? Yeah, just repeat what you were saying.
So what else is significant is because there's a proliferation of telemarketing, whether phone calls or text messages, that some states have adopted additional laws where it can actually be up to $5,000 for every single one of these calls. And so again, it goes back to the point of before you implement an idea in terms of how you're doing marketing, you might have an idea or a concept or a goal of how you want to market, what you want to say in your marketing, things like that. Spend a little bit of extra money on the front end and have a lawyer go through what you're trying to achieve and exactly how you're trying to achieve that to make sure that you don't walk into one of these pitfalls.
And I totally agree. And I know because I coach a lot of small businesses and I hear this from them all the time. I don't want to spend my money on that. Or and it's usually around legal advice. It's like, it's good enough. I went online. But no, it's not. You need to have an attorney review what you're doing, just like you would a contract or a lease negotiation. It's very important because it's your business that can cost you a lot of money on the other side, like you said.
I mean, that's exactly right. If you don't comply with the law, and a lot of these things are not really complicated to comply with, it's going to cost you potentially a lot more down the road. Mm-hmm. And we can talk about it. I know we're going to talk a little about insurance and things like that, but that doesn't always cover it. And so you need to be very diligent about that on the front end. I mean, it's almost like your health, right? Like you, from a personal perspective, you want to exercise and eat healthy to prevent things from happening down the road rather than getting sick and then trying to fix things later on. It's much more difficult to do that.
Right.
And so just like when you're trying to implement these things or start a new business, that's why it's so important to have a good legal counsel on your side.
Right. And now I know you probably don't, and I don't, may perhaps you do, but well-drafted contracts, whether it be between you and your customer or you and a vendor, whatever the case may be, important, I would guess.
Absolutely important. And especially business to business, especially consumer to business. And one thing that has prevented me from filing a lot of lawsuits, and it's a little tip that I would give your business audience here, is to put what's called an arbitration provision and a class waiver provision in your contracts.
Okay.
What that does, if they're properly drafted, is it makes it difficult for a consumer who has a grievance to, number one, bring a case in court. They would have to bring in an informal proceeding, not informal, but a less formalized proceeding known as arbitration, which can be more cost effective. And also, it precludes, for the most part, depending on how the provision's drafted, consumers from bringing a class action. So they might have a small damage, but now you've insulated yourself from having a larger damage in terms of that being a class action. And the United States Supreme Court has repeatedly blessed those contracts. And I can't tell you how many great cases. I hate them. I hate these provisions. But I can't tell you how many good cases I've seen come into my office, and these provisions are there. And so when they're written properly, they can be lifesavers for especially small businesses.
Now, I want to go back for a second, just in case our listeners don't understand what a class action lawsuit is. Can we talk about that quick?
Sure. I appreciate you asking that. So a class action lawsuit, the easiest way to think about it is this. So a business might shortchange you by $100. Well, there's a famous judge named Justice Posner from the Seventh Circuit, and he has this quote, and it says, "Only a lunatic files a lawsuit over $30." Okay, so most people don't file a lawsuit over 30 or $100. But if a business has a systematic practice of, let's say, shortchanging somebody by $100, now a single person can bring that case as what's called a putative class action, and that means they're not only trying to represent themselves, they're trying to represent the thousands, tens of thousands, hundreds of thousands, sometimes millions of people that have also been shortchanged in this way. So in our example, instead of exposure for $100, it's $100 times 1,000, 10,000, 100,000, a million people. And when we go back to our earlier example of a phone call or a text message, let's say somebody only got 2 text messages. Well, that might be $1,000 for that person. But if there's 1,000, even if there's only 500, 1,000 people that are called, that is 7-8 figure liability in a hurry. And so a class action is basically an efficient way to pool all these potential claims into a single case. And hopefully that explains it a little bit, but it creates potentially large financial exposure for business.
That makes sense. Now, I have a question about this too. We're talking about class action, and when you think of class action, it's typically, like you said, they shortchanged a customer by 100, and maybe it's tens of thousands of people. Is this permissible from an employee standpoint? Can an employee do a class action lawsuit?
Absolutely. Yeah, absolutely. We've recently filed one, for example, under the Fair Labor Standards Act. Sometimes these things are called collective actions. Sometimes I'm not going to get into the legal nerdity of a collective action versus a class action, but conceptually they're very similar. So I can give you an example. We've had cases where an employee or an independent contractor is misclassified, for example, as an independent contractor when they should really be an employee.
Sure.
That's the biggest one we see. The other thing, there's cases called donning and doffing cases where, for example, people are required to wear certain uniforms at a job, but the work requires them to clock in after they put that uniform on, and the people by law are supposed to be compensated for that time they're putting on the uniform, taking it off. So we've had cases like that as well. So there's all sorts of employment-related class actions that are out there as well. They're obviously different breed than some of the advertising, but the concept is the same, that a small amount of damages, maybe you're not paying overtime to an independent contractor and it's only $1,000, but if you've got 10,000 employees, that can add up in a hurry.
Totally. I know that would be an area that most people would not think about, the whole uniform situation. Like, most people come to work. If you're working somewhere that you have to wear a uniform, you're usually wearing it.
Right. And a lot of these cases come up where, like, you're maybe in a plant and you have to actually go to the site and put your uniform on. It's not usually in the context of somebody working at Walmart and they've got to put their their bright reflector outfit on before
Right.
they go into work. But those are the types of cases that you'll sometimes see class actions arise under.
Okay. Do you do a lot with intellectual property at all?
I do not.
Okay.
All right.
Any thoughts on how people can really protect it? And maybe you don't because that's not the area that you practice in, but any thoughts for our listeners on intellectual property?
It's very important to be cognizant of images and videos that you use. I go back to the same advice I had earlier in terms of an ounce of prevention is worth a pound of cure. Get a copyright lawyer, get a trademark lawyer. If you need, get a patent lawyer.
Mhm.
It can be ruinous for businesses, for example, to come up with this idea, spend tons of money on branding, only to learn that somebody else is using the mark in the scope of commerce and you can't use the mark anymore. You'd rather know that up front.
Right.
And, let me give you kind of an embarrassing personal story on this regard. I'm a business owner. I'm an owner of my 2-person law firm.
Mhm.
This is years ago, but I run the Facebook page for our firm, and nobody's on. We have like 300 followers. We're not really big on Facebook, but I found an image, and I thought it was a Creative Commons image of a gavel, and it said something like consumer law. And so I put it up there. It was not even on the front page. It was some obscure part of the Facebook page, and I get a letter. The law firm gets a letter saying, "Hey, this is a copyrighted image. Pay us,
Mhm.
$1,000 to settle the case." And we ended up resolving it before there was any litigation or whatnot. But it was an important lesson to me
Mhm.
to be absolutely certain that the images and the videos that you're using in your promotional materials are things that you are allowed to use. Sounds, images, videos, all those things. So I encourage people to be cognizant of that.
And I had something similar happen to me. We posted it on Facebook and it turned out to be somebody else's. And we didn't actually post it, but a marketing agency that we work with posted it, but we were still on the line for it. And we settled, obviously, without needing to get anyone involved, but that it hurts. And
Yeah,
it scares the bejesus out of you. I've got to say, you get this letter and you're like, what?
it makes you a little nervous, and I mean, the positive of it is a learning experience, and
Hmm.
so like going forward, kind of how to do things, and sometimes the best life lesson is kind of a negative experience, and
Right.
so. But yeah, people have to be very cognizant of that. But there are lawyers that specialize in patents. There's lawyers that specialize in copyright and
Mhm.
trademark, things like that.
Now, what role does documentation play in the realm of all possible litigation issues, legal issues that small businesses can face?
Now, when you say what role documentation means, can you be a little more specific? I just want to make sure I give you a
Sure. Like, should we be documenting absolutely everything that we do and putting it in a file and um, if we were properly documenting things, would that help us when we're up against someone who's suing us? When we're up against you in court?
Well, it depends, right? Because as part of that documentation, there could be a smoking gun, right?
True.
There
True.
could be something very negative. I go back to the kind of fundamental advice, though, and I think a lot of what you're referring to, probably more in terms of the documentation, comes up in the context of employment-related
Sure.
issues, right? Like hiring, firing, reprimand, things like that.
Mhm.
Have an employment lawyer develop these policies and procedures for you. If you've got HR professional, work together with you on that. I'm not an employment expert,
Mhm.
but I have enough sense to know that, like, if I'm starting a business and I'm going to have I'm going to have employees and multiple employees working for me, you need to have these systems in place. And
Mhm.
so the employment lawyer will be able to best steer you in the right direction in terms of what documentation should be kept, which documentation should be made in the first instance. I mean, no one should ever be like destroying documents or anything like that. But I don't think employment lawyer might say differently, but I don't think we have to record every single thing.
Right.
But that's how I would go about it, is again, seek legal counsel's advice on that. And I know it sounds like I'm suggesting you seek legal counsel's advice for every single thing, but
Speed dial.
but yeah, but it's just because of the perspective I have, and we actually will occasionally do some defense work, but because we do so much plaintiff's work and filing these cases, I see kind of the other side of this.
Right.
And so a lot of it, like, for example, we had a company that we have settled now 5 class action lawsuits with.
Against one company.
Case after case after case after case. And I have a good relationship with their lawyer. And I said, look, just kind of in half jest, you know what you guys should do is really, you should hire me to come in and like just go through this and tell you how I would go about suing you, because then you develop those policies and procedures and protocols to avoid it from happening. And so that's why I have that suggestion: turn back to legal counsel. You know, there's counsel will do it at a reasonable rate. Not everyone's charging $1,000 an hour. There's people that will be flexible with you that are good and that are local and that are not all at big firms. So that's what I would really, really emphasize to the audience.
And again, going back to an ounce of prevention, right?
Yep. That's right.
So, insurance. Is there any kind of insurance that will protect a small business against being sued for class action lawsuits, whatever kind it is?
That's a great question, and it's a very, very complex question. It depends. Usually in insurance law can vary from state to state, but generally speaking, whether there is coverage that is invoked depends on what is alleged in the lawsuit. Many policies cover general negligence. However, for example, in the telemarketing cases that I've been talking about, that's called the Telephone Consumer Protection Act. Because so many businesses were sued under the Telephone Consumer Protection Act, now it's more common than not to actually have specific exclusions for claims brought under the Telephone Consumer Protection Act. So it really depends on the type of case that is brought. But here is my suggestion to the audience in this regard. You should have a good relationship with 2 people. Number one, the person that's selling you your insurance. You need to tell them exactly what your business is, what your goals are, how you intend to achieve those goals. So you intend to do marketing, this way, that way, or the other way. So if you're doing telemarketing, you want to let them know that. But in the insurance agent, you should say, look, this is what I'm concerned about. Like, I think we've got our ducks in a row, but we might be concerned about a crazy person, like Chris, suing us for X, Y, and Z. I need coverage for that.
Right.
Now, they can say, yeah, you're covered under this, but you should not take them at their word on that, because ultimately what determines whether you're covered is not what the insurance agent's telling you, it's the policy. So again, it's good to have a good legal counsel in your back pocket, because before you sign or before you enter into that policy of insurance, it would be helpful to have counsel look at that. They know your concerns, they know your objectives, and so they can tell you, you know what, it's this type of thing's likely covered, this type is not, and you can make the determination whether or not you want that coverage. Maybe you need to pay a little bit extra to get a supplemental rider on that insurance. It's really important to have an open dialogue with the insurance broker or agent and your counsel to make sure that if that's something that you're concerned about, and some people should always have this in the back of their mind, especially if they're in like a services or a product-based business, that you have good counsel on your team.
Absolutely. I have another question with regard to, I really want to know, and this is going to catch you off guard perhaps, but what is the most interesting case that you've done? And you don't need to share names. That's great. We don't want that. What is the most interesting case that you've done in the business world?
In the business world, just in terms of me being a lawyer, or with against the business, or
Right, like going up against a business. I mean, besides the person that has been sued 5 times and not learned
right,
the
right.
lesson.
So actually, one of my more interesting cases and more impactful cases is actually an individual case.
Oh,
And so it was against a loan company. And here in Missouri, believe it or not, there are no caps on interest rates. So
wow.
so I've represented, for example, people that have taken out loans with over 750% interest.
Oh my gosh.
Yeah, yeah.
How is it even legal?
Our The powers that be in the state of Missouri have not prevented that practice from occurring. I'll
Wow.
leave it at that. So a lot of people refer these as payday loans. They're
Mhm.
really kind of referred to as consumer installment loans here in Missouri. What happens in Missouri courts is that we have different levels of court. There's basically courts where the damages are over
Mhm.
$25,000, and there's courts where damages are less than 25,000. Okay, so the damages less than 25,000 tend to be credit card debt, tend to be these small loans, things like that. And there's tens of thousands of these cases filed every year. And so the lawyers that handle these cases, collection lawyers, they're bulk filers. They might have a couple thousand cases, and they just kind of churn these cases.
Mhm.
So I had a client that took out a loan for, I believe it was $1,000. The interest rate on that was I think it was close to 200%. It might have been 180, 190%. And what the game is in these courts for the collection lawyers is they want to get a judgment against you, because
Sure.
then they can garnish your wages, they can levy
Mhm.
your bank account, they can put liens on your property, things like that. But because there's so many files, sometimes these lawyers don't pay attention. And so before you take a judgment, you have to serve somebody with the lawsuit papers. So my client has a judgment entered against her, and it's for a couple $1,000 because the $1,000 had accrued interest. Okay.
Mhm.
Then what happens in Missouri? Let's say you got $1,000 loan, $1,000 of interest. $2,000 becomes the new principal balance, and the 180-90% starts accruing on the new principal balance.
Wow.
Right? So client comes to me, and she's been garnished for like 3 years, and she has been garnished on this $1,000 loan about $6,000. And at this point, after 3 years, because of the interest rate, her balance is still higher than the original balance. She hasn't made a dent in anything.
Mhm.
So I look at the case and I say, oh my gosh, the document they filed with the court literally says you were never served. It says you were never served. And then in the meantime, I had filed a separate class action lawsuit against this company for improper service. Basically, the people that were serving the papers were not approved by the court to serve the papers. So
Wow.
then what they did in the case is they try to correct their screw up. They filed a document 2 years later trying to correct it, and that document said the lady still wasn't served.
Oh my goodness.
So 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 I get into the case, I get the judgment set aside, I get the garnished funds returned to my client, and I turn around and sue them. And we took the case to a jury trial in St. Louis, and the jury awarded her $225,000.
Wow.
And so it's not a massive case in terms of some of the numbers that you hear, but it was really impactful for my client because she went from just completely being taken advantage of, never
Mhm.
seeing it in sight, like basically a modern day form of indentured servitude. You're just
Right.
paying that forever, to having them actually pay her. So that was one of the most interesting and most rewarding cases I've certainly done in my career.
Wow, that's quite interesting.
It,
Crazy.
it,
I mean,
yeah, people don't realize it happens, but I've had people with $300 loans because the judgments and whatnot owing $12,000 of interest a single year on those loans.
that's just I
It's
didn't know that
crazy.
happened.
Yeah.
You would
Yep.
never know.
Nope.
Well, is there anything else that you would like our listeners to know with regard to how they can stay out of legal trouble and not meet you in court?
It's just spend the time and the money to have a good counsel, to be open with your counsel about exactly what you want to do, exactly how you want to do it, because that counsel is going to help you draft agreements, draft policies, draft protocols, draft procedures, how you can market, things like that, to steer you clear of trouble. Now, what we do from my perspective, people might be scared of us, but in reality, it's a very useful tool in society, because businesses that do things the right way
Mhm.
should be rewarded. Businesses that do things the wrong way and don't play the rules should be penalized, so that the businesses that are doing things the right way continue to thrive.
Right.
And the best way to continue to thrive is to comply with the law. Obviously, not all entrepreneurs are lawyers, so it's good to have somebody on your side that knows the law and that can make sure to steer you in the right direction, and to keep you clear of people like me, I suppose.
Absolutely. Well, it has been insightful speaking with you today, Chris. If our listeners would like to get in touch with you, how can they do so?
Sure, I appreciate the opportunity to be here. The easiest way is to go to my website, which is classactionguru.com, guru.com. I'd give you my email address; it's on there, but everyone will misspell it. But you can go to classactionguru.com. If you can schedule a free Zoom meeting with me through there, I'd be happy to speak with you. And I really appreciate the opportunity to be here.
Absolutely. Thank you so much again. And thank you to all of my listeners. We'll see you again.